In a landmark judgment, Supreme Court recently indirectly upheld the minority status of Aligarh Muslim University. This will make Article 30, which was in question in this case, very important for your UPSC Prelims 2025 exam. Let us try to understand the chronology of this case. In 1877, Sir Syed Ahmad Khan, a very well-known Muslim reformer of the 19th century, founded the Mohammedan Anglo-Oriental College or MAO College at Aligarh. Through this institution, he sought to popularize modern British education among Muslim society while balancing and protecting Islamic values and principles. Although it was an institute primarily for persons of the Islamic faith, MAO College was open to other communities as well. The Aligarh Muslim University Act 1920 was passed by the then Indian legislature to incorporate the MAO College and another Muslim University Association into a single university called the Aligarh Muslim University. According to the AMU Act, the court of the university, that is the governing body of the university, would only consist of persons belonging to the Islamic faith. In 1951, the AMU Act was amended to do away with the compulsory religious education provided to Muslim students by the university. Further, the amendment removed the provision which mandated only Muslim representation in the court of the university. Later, the AMU Act was again amended in 1965, and the court was no longer the supreme governing body of the AMU. It became a body whose members were nominated by the visitor, that is the President of India. The powers were distributed among other bodies of the university, like the executive, to democratize the management. The then S. Aziz Basha and another versus Union of India in 1967 case came up, wherein the university argued that the amendment violated their right to establish and administer educational institutions under Article 30 Clause 1 of the Constitution of India. Further, they contended that the amendments violated the institution's right to carry out religious and charitable causes under Article 26, their freedom of religion under Article 25, the right to conserve culture and language under Article 29, and the right to acquire property under Article 31. In this case, the Supreme Court's 5-judge bench held that no fundamental rights of the petitioners were violated and upheld the amendment. The bench reasoned that AMU was neither established nor administered by the Muslim minority by pointing out that the act was enacted through a central legislation. However, in fear of backlash by the Muslim community, the then Indian government in 1981 amended the act to redefine university as an educational institution established by the Muslims of India, which was initially MAO College and later became AMU. The act was amended to include a new clause for promoting the educational and cultural advancement of the Muslims of India. In 2005, the AMU reserved 50% seats in postgraduate medical courses for Muslim candidates by claiming it to be a minority institution. This was again challenged in Dr. Naresh Agarwal versus Union of India 2005. Petitioners relied on S. Aziz Basha to argue that AMU is not a minority institution. However, the Union government at the university contended that S. Aziz Basha was nullified by the 1981 amendment. However, the Allahabad High Court struck down the reservation policy and upheld that AMU could not have an exclusive reservation policy because it was not a minority institution, according to S. Aziz Basha. In 2006, a division bench of Supreme Court put a stay on the reservation policy of AMU. The constitutionality of the policy was referred to a larger bench to decide. In 2024, a 7-judge bench gave the verdict. The Supreme Court recently overturned the 1967 ruling in S. Aziz Basha versus Union of India, which had held that AMU is not a minority institution, and to enjoy this status, it should have been both established and administered by the minority. The court did not directly decide whether AMU is a minority institution or not, leaving the determination to a regular bench to investigate AMU's historical establishment. However, it laid down a new test for determining minority status of an institution. First, to identify the brain behind the establishment, including reviewing correspondence and documentation that reflect the intention of the founders. Second, to assess whether the administrative structure of the institution affirms its minority character and serves to protect and promote the interests of the minority community. The court held that an institution's minority status shouldn't be dismissed solely because it was created by law, and courts shouldn't rely strictly on legislative language to determine its establishment. The court stated that this would make Article 30 Clause 1 a fundamental right subservient to a statutory enactment. The court held that the word established as used under Article 30 Clause 1 cannot and should not be understood in a narrow and legalistic sense. The words used in Article 30 Clause 1 have to be interpreted in view of the object and purpose of the article and the guarantee and protection it confers. However, a regular bench is supposed to look into this issue again and finally determine whether the actual minority status is to be conferred upon AMU or not. AMU's recognition as a minority institution could help it to reserve seats for Muslim students in various programs without needing to adhere to general reservation policies. This brings us to the end of our video. We hope that you found it informative for your exam preparations. Please click on the like button, share our videos with your friends, and subscribe to our channel on YouTube and follow us on Instagram. Thank you for watching this. I will see you in our next.